Grand Rising. Today is Tuesday, July 25th, 2023 on the ancient moon calendar, 2024 on the ancient sun calendar, and 2023 on the Greco-Roman calendar. Empire State of Morocco, United States for America, Moorish National Republic Federal Government. Societas Republicae e Almorcanes, Moorish Divine and National Movement of the World. Northwest America, Northwest Africa, North America, the North Cape, and the adjoining Amerikan islands. Temple of the Moon and Sun, the true and de jure natural peoples, heirs of the land. Islam. I, Sub, Law, and Master. Universal, Sovereign, Original, Indigenous, Natural, Divine, Quoranto, Mandamus, Restitutio, Mitimus Writ. Affidavit of fact. Default judgment for non-appearance in response to summons to hearing for jurisdiction. MACS Court of Action K000001. Notice to agent is notice to principal. Notice to principal is notice to agent. All rise and stand and remain standing into perpetuity. This is a sovereign living ancient article to Moorish American and Moroccan universal court action. I am sovereign, living, justice, Sharon, and peart. My free chosen sovereign appellation of nobility is shasha, ande, and my sovereign matrimonial appellation is sharon and martini. All are in capitis, diminuto, nolo, in red ink, in proprio persona sui juris, in proprio solo, and in proprio heredes. I and all Moors are the sovereign living justice in capitis, diminuto, nolo, in red ink, in proprio persona sui juris, in proprio solo, and in proprio heredes. We are capit et corpus juris legalis, which is our statement that we are the lawful and legal natural head and body for our empire. All Moors are the original indigenous, sovereign, ancient, and Moroccan Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith and trust, our allegiance, our credit, and our energy are hereby vested in ourselves. For we are the people who are the original indigenous, natural, divine, sovereign, ancient empire states of Morocco and the de jure Moorish National Republic Federal Government, Washington District for Columbia, the Universal Moorish American Consulate, and the Earthwide Article 3 Moorish American Consular Court. Today we are exercising the law by our sovereign status, which is the original indigenous, natural, divine, sovereign, ancient Article 3 living United States District for Columbia Court. And we are the sovereign fiduciaries, creditors, executors, trustees, ministers, possessors, and titled beneficiaries for this cause for action. We are peace. We, the one nation, are not at war. We are one state, one empire, and one God. We hereby recognize ourselves and accept our sovereign ascension. We issue a universal creditor's bill for possession and custody over all land, all natural resources, all commerce, and all property. We, the one true God nation, exercise all ancient sovereign rights at this time and at all points in time. Let me not, I pray you, accept any man's person, neither let me give flattering titles unto man, for I know not to give flattering titles. In so doing, my Maker would soon take me away. Job 32, verse 21 and 22. Put on the whole armor of God, that ye may stand against the wiles of the devil. For we wrestle not against flesh and blood, but against principalities, against powers, against the rulers of the darkness of this world, against spiritual wickedness in high places. Ephesians chapter 6, verse 11 and 12. Adrian Williams, number 13196, subject in the office of Constable, Jamaica Constabulary Force, and all heirs, assigned, principals, agents, and derivatives thereof, Everton Williams, number 10119, subject in the office of inspector to make a constabulary force and all heirs assigned principals, agents, and derivatives thereof. And at the address, Pedro Plain, Police Station, Pedro Plain, St. Elizabeth, Jamaica. Phone 876-965-2259, fax 876-624-4178, email everton.williams@jcf.gov.jm, adrianwilliams@jcf.gov.jm. Broderick Smith, subject in the office of Chief Parish Judge, St. Elizabeth Parish Court, and all heirs assigned principals, agents, and derivatives thereof. Latoya Rule, subject in the office of Clerk of the Court, St. Elizabeth Parish Court, and all heirs assigned principals, agents, and derivatives thereof. 58 High Street, Black River, St. Elizabeth, Jamaica. Phone 876-965-2259, fax 876-634-4178. Email broderick.smith@rnc.gov.jm, St. Elizabeth.rnc@rnc.gov.jm. Stare decisis. Courts are constituted authority and they cannot act beyond the power delegated to them. If a court acts without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a remedy sought in opposition to them, even prior to a reversal. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Elliott versus Purcell, 26 U.S. 328, 248-1829. There are no lawful judicial courts operating under the jurisdiction of the United States Corporation doing business at North America. Lawful courts have not been in existence since 1789. Article 3 judges do not enforce statutes and codes. Executive administrators enforce statutes and codes. FRC versus GE 281 U.S. 464, Keller versus PE 261 U.S. 428 1 statute 138 underscore 178. There have not been any lawful judges within the jurisdiction of the United States Corporation doing business at North America since 1789. There have just been administrators. Again, FRC versus GE 281 U.S. 464, Keller versus PE 261 U.S. 428 1 statute 138 underscore 178. There is no discretion to ignore lack of jurisdiction. Higgins versus Levine 415 U.S. 533. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Basso versus Utah Power and Company 495 F 2D 906-910. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction to hear is void ab initio. In re application of Wyatt 300 P 132 RE Cabot 115 P2 D 856. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the policy enforcers cannot make void the exercise of rights. State versus Armstead 60X 778, 779, and 781. The use of highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and natural sovereign beings cannot be rightfully deprived. Chicago Motor Coach versus Chicago 337, Illinois 200-169, NE22, ALR Legare versus Chicago 139, IL 4628 HU934, Boone versus Clark 218 West 607 25 AM. Juror First Highway Section 163. Policy enforcer, masquerading as peace officer, otherwise known as police. Power extends only to immediate threats to public safety, health, welfare, etc. Michigan versus Duke, 266 U.S. 476 LED at 499, which driving and speeding are not. California versus Farley, CED, RPT 89, 20 CA3D, 1032, 1971. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public. And such a traveler owed nothing more than due care as regards to tort for negligence to the public, and the owner owed no other duty to the public, e.g. corporate state. He/she and his/her auto having equal rights to and on the roadways/highways as horses and wagons, etc. This same right is still substantive rule in that speeding, running stop signs, traveling without license plates or registration are not threats to the public safety and thus are not arrestable offences. Christie versus Elliott, 216-1131, 74HE, 1935M, LRANS 1905 to 1910, California versus Farley, 98, CED, RPT 8920, CA3D, 1032, 1971. Further, the right to travel by private conveyance for private purposes upon the common way cannot be infringed. No license or permission is required to travel when such travel is not for the purpose of commercial profit or gain on the open highways operating under license in commerce. Shapiro versus Thompson, 394 U.S., 618, April 21, 1969. An illegal arrest is an assault and battery. The person so attempted to be restrained of her/his liberty has the same right to use force in defending herself as she would be in repelling any other assault and battery. City of Dallas versus Mitchell, 245, Southwest 944, State versus Robinson, 145 ME 77, 72 ATL 20, 260. The claim and exercise of a constitution right cannot be converted into a crime. A denial of them would be a denial of due process of law. Simmons versus United States, 390, U.S. 377, 1968. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384, U.S. 426, 491, 86, SCT 1603, Supreme Court, 1603. There can be no sanction or penalty imposed upon one because of his exercise or her exercise of constitutional rights. Scherer versus Cullen, 481 F. 936, 1973. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of this constitutional right, or because of this unalienable. Scherer versus Cullen, 481 F. 945. Corpus delicti consists of a showing of 1, the occurrence of the specific kind of injury to another of the same species and status, and 2, someone's, as in a living woman or man, criminal act as the cause of the injury. Pruden versus Neal, 2 MC 338 S SE 70. The requirement of standing, however, has a care component derived directly from the Constitution. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by the requested relief. Allen versus Wright, 468, United States, 737, 751, 1984. All officers of the court are required to take an oath of office to uphold the Constitution for the United States, 1789 and 1791. Whoever, having taken an oath before a competent tribunal, officer or person in any case in which a law of the United States authorizes an oath to be administered, willfully and contrary to such oath states or subscribes any material matter which he does not believe to be true, is guilty of perjury and shall be fined no more than $2,000 or imprisoned not more than 5 years or both. Title 18 United States Code 1621. Bills of attainder, as they are technically called, are such special acts of the legislator as inflict capital punishments upon persons supposed to be guilty of high offenses such as treason and felony, without any conviction in the ordinary course of judicial proceedings. If an act inflicts a milder degree of punishment than death, it is called a bill of pains and penalties, but both are included in the prohibition in the federal constitution. Lozier versus Sherman, 157 Kansas, 153, 138 B2D, 272, 273 State versus Graves, 352 MO, 1102, 182 Southwest 2D 4654. It shall be unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity or collection of unlawful debt. Racketeering Influence and Corrupt Organizations Act, RICO, 18 United States Code 1962. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him, and in alignment with the organic constitution or laws for the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with the intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death. Title 18, United States Code, Part 1, Chapter 13, Subsection 241. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by or in alignment with the organic constitution or laws for the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, that are prescribed for the people, shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or for life or both, or may be sentenced to death. Title 18, Part 1, United States Code, Chapter 13, Subsection 242. Title 42, United States Code, Section 1983, Section 1985, and Section 1986. Clearly establish the right to sue anyone who violates your constitutional rights. The Constitution, let me start again. Clearly establish the right to sue anyone who violates your constitutional rights. The Constitution guarantees he who would unlawfully jeopardize your property loses property to you. And that is what justice is all about. Whereas I, sovereign living Chief Justice Sharon and Peart Johnson in capitis diminuto nolo in Reading in propria persona sui juris in proprio solo and in propria heredes, am neither ens legis, strawman, black, colored, negro, Jamaican, corpse, dead, or lost at sea. I am not subject to the Christian black codes, nor any codes, rules, acts, statutes, ordinances, regulations, etc. I am in full life, in propria persona sui juris, in my own proper person. I am sovereign, and no court can challenge that status or standing. Be it known that I, sovereign living Chief Justice Sharon and Peart Johnson, and all Moorish American nationals, otherwise known as Moors, are the supreme law for the land, with superior jurisdiction here at the land of Jamaica, otherwise known as Jamaica territory, and earthwise, I and all Moors are the universal, sovereign, original, indigenous, ancient, natural, divine fiduciaries for the sovereign living state of and for ancient Morocco, also appellationed as the Maghrib al-Aqsa, the land most extreme west, the North Gate, North America, and the adjoining Antilles, Atlantis, Amerikan Islands. Northwest of Mexican Turtle Island, among other sovereign land appellations. No United States corporation, company, or citizen, or any other foreigner has per annum jurisdiction over me or over any more. No United States corporation, company, citizen, nor corporate venue has legal authority and thus cannot render judgment over me or any Moorish American national more. And any and all actions by the United States corporation, company, citizen, and all heirs, assigns, agents, principals, and any and all derivatives thereof are coram non judice, in the presence of a person, not a judge. In as much as every government is an artificial person, an abstraction and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contract between them. Supreme Court Reporter, 1795, 3 United States, 54, 1 LED 57.3 Dow 54. The Supreme Court states only the dead can appear in the foreign private for-profit racketeering, criminal, human trafficking, corporate venues. The maxim of law of like kind unambiguously states, disparata non debent jungi. Dissimilar things ought not to be joined. Paper, a fictitious contract entity, artificial person, corporation to paper, and flesh, the living, to flesh, but not paper to flesh or flesh to paper. Thus, there is no, nor can there be lawfully or legally corporate jurisdiction over the natural living woman, sovereign woman, any living man or woman. When a suit is brought and determined in a court which has no jurisdiction in the matter, then it is said to be coram non judice, and the judgment is void. Manufacturing Company versus Holt, 51, West Virginia, 352, 41, SE 351. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. See Old Wayne Much, Association versus McDonough, 204 United States, 827 Supreme Court, 236, 1907. Whoever, under color of law, willfully subjects any person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be guilty of a crime. Section C-18 United States Code, subsection 242. On or before April 12, 2023, notice was given to you, Adrian Williams, number 13196, subject in the Office of Constable, Jamaica Constabulary Force, and all heirs, assigns, principals, agents, and derivatives thereof. Everton Williams, number 10119, subject in the Office of Inspector, Jamaica Constabulary Force, and all heirs, assigns, principals, agents, and derivatives thereof. Broderick Smith, subject in the office of Chief Parish Judge, St. Elizabeth Parish Court, and all heirs, assigns, principals, agents, and derivatives thereof. Latoya Rule, subject in the office of Clerk of the Court, St. Elizabeth Parish Court, and all heirs, assigns, principals, agents, and derivatives thereof, of the affidavit of quo warranto, mandamus, restitution, mandamus, mittimus, summons to hearing for jurisdiction for unlawful bill of attainder, kidnapping, unlawful arrest, imprisonment of treason, fraud in the inducement, assault, sexual assault, robbery, et al. See public record, youtube.com/watch, !v equals CZR5JWVXDYU absentee equals 2287S. You are commanded to appear at the Moorishe, American, Moroccan, Article 3, Consular Court at Universal Area Code 8HL 5CPKZC 72J via video. Wednesday, 12th of April 2023 at 10 off the clock ante-meridian to state your name and nationality for the record and the Moorishe, American national people, and to make available your delegation of authority and surety bond as legal and lawful evidentiary proof for my review and examination to prove jurisdiction in this court of action. You fail to appear, no answer is silence, silence is acquiescence. Your failure to answer and produce the above evidence constitutes default and serves as your admission by silence to the collusive actions of fraud. Fraud in the inducement, treason, conspiracy against rights, 18 United States Code 240, subsection 241, deprivation of treaty rights, under color of law, 18 United States Code, subsection 242, trespassing, kidnapping, denationalization attempted, under the Christian Black Codes, robbery, sexual assault, assault, kidnapping, hostage holding, unlawful imprisonment, impersonation of judicial officer, fraud, robbery, extortion, coercion, breach of oath, breach of office, breach of treaty and constitutional obligations by color of authority and color of office, under color of law, and is conclusive proof that you, subjects of Jamaica Constabulary Force and St. Elizabeth Parish Court, that's SAINT, correct that, on the record, let the record show that it is SAINT, St. Elizabeth Parish Court, on the land, and all heirs, assigns, agents, principals, and any and all derivatives thereof. You have no valid claim. Silence is tacit acquiescence and can only be equated with fraud where there is a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. United States versus Tweed, 550P2D297. Therefore, by your silence, upon default, constitute acknowledgement of every word, sentences, and paragraphs written within this said notice as truth, the whole truth, and nothing but the truth. Silence can only be equated with fraud where there is a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. Supra P 1032 United States versus Tweel 550P2D297. Fraud vitiates the most solemn contracts, documents, and even judgments. United States versus Throckmorton, 98 United States 61. It is hereby ordered and adjudged that you all claims, petitions, suits, filings, all misrepresented bills of attainder, foreign bill of exchange, de facto case numbers B009712473, B009712472, B009712475, B009712474, petty sessions and any other petty session summonses, subpoenas, and any other attachments, adhesions, joinder associated thereto, all of which are invalid, unconstitutional, notwithstanding, not merely void, but void ab initio. What begins in fraud stays in fraud, and unenforceable, are dismissed immediately with prejudice for lack of jurisdiction, fraud, and treason. It is hereby ordered and adjudged that you are commanded, all of you previously named in this affidavit, are commanded to cease and desist from all further attempts at inducement to defraud, trespass, and escheat of the property, land, and estate of sovereign living Moorish American national Sharon and Peart Johnson. It is hereby ordered and adjudged that you are commanded. Oh, we have a duplication, but yeah, we'll repeat it. It is hereby ordered and adjudged that you are commanded to cease and desist from all further attempts at inducement to defraud, trespass, and escheat of the property / land and estate for sovereign living Moorish American national Sharon and Peart Johnson. It is hereby ordered and adjudged that you are commanded to immediately return all stolen sovereign property held in trust for sovereign living Moorish American national Sharon and Peart Johnson, to include but not limited to Subaru Forester 2006 XT Turbo conveyance. It is hereby ordered and adjudged that a default judgment is entered against each of you, Adrian Williams, number 13196, Everton Williams, number 10119, Broderick Smith, and Latoya Rule, and all heirs, assigned, principals, agents, and any and all derivatives thereof, for each of you, hereinafter judgment debtors, pursuant to Federal Rule of Civil Procedures 55A. It is further ordered and adjudged that each judgment debtor named in this course of action and all heirs, assigned, agents, principals, and any and all derivatives thereof is obligated to me, sovereign living Moorish American national, sovereign Chief Justice Sharon and Peart Johnson, in capitis diminuto nolo in Reading, in proprio persona sui juris, in proprio sola, and in proprio heredes, for the following judgment. The total sum principal amount of $262,003,000 United States dollars, payable in lawful money of gold or .9999 fine silver, bullion, coins, or bars for compensatory damages. Evidence that motorist cited for traffic violation was incarcerated for 23 minutes during booking process was sufficient to support finding that municipality employing officer who cited motorist and County Board of Criminal Justice, which operated facility in which motorist was incarcerated, had unconstitutionally deprived motorist of his right to liberty. 42 U.S.C. A. Section 1983, Trezevant versus City of Tampa 1984, 741F 2D 336HN1. It is further ordered and adjudged that this default judgment shall serve as a judgment lien against the oaths of office, surety bonds, and all property real and personal, corporeal and incorporeal, and assets of the judgment debtors and all heirs, assigns, agents, principals, and any and all derivatives thereof, in order to secure the performance of this judgment and to levy on such property and assets for the satisfaction of this judgment. This payment cannot be made. All officials are required by federal, state, and municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company and the policy number of the bond, and, if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud, 15 United States Code, and is prima facie evidence and grounds to impose a lien upon the official personally to secure the public oath and service of office, 18 United States Code 912. Sovereignty itself remains with the people, by whom and for whom all government exists and acts, and the law is the definition and limitation of power. Yick Woe versus Hopkins 118 U.S. 356-370. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yick Woe versus Hopkins 118 U.S. 356-370. I do not, under any condition or circumstance, by threat, duress, or coercion, waive any rights, inalienable or unalienable, in alignment with the Organic Constitution for the United States, 1787-1791, and the Treaty of Peace and Friendship, 1787 and 1836, and hereby command you to fulfill your obligation to preserve the rights of this Moorish American national and all Moors and our subjects, and carry out your judicial duty in good faith. Upon my inherited status, I, Sharon and Peart Johnson, in capitis diminuto nolo, in Reading, in proprio persona sui juris, in proprio solo, and in proprio heredes, a sovereign, living, original, indigenous, natural, defined, flesh and blood, sentient, Moabite woman, part and parcel to the land, for my ancient foremothers and forefathers, being an ascendant of the ancient Moabites, in other respect known as American, Moroccan, Moor, Amuru, by birthright, jus sanguinis, and inheritance, declaring my full life force and authority by right of birth and right of soil, exercising all of my sovereign rights affirmed by virtue from divine law, standing squarely affirmed with my oath to the 5 points of light, love, truth, peace, freedom, and justice, being competent in my own proper person to attest in this affidavit upon which I place with clean hands over Akka, my sovereign autograph and seal, do hereby state, proclaim, and declare the following to be true, correct, not misleading, and not intended to be presented for any misrepresented, colored, or improper use or purpose, and in favor of all Moorish American nationals, anciently known as Moroccan. Ignorantia juris quodquisque teneture sciere neminem excusat. Ignorance of the law is no excuse. An unrebutted affidavit stands as law. This sovereign justice is the law. This sovereign justice stands as the law. The Provost Marshal has been notified. Nothing in this lawful document shall be misconstrued or implied to consent to any jurisdiction other than my ancestral inherited estate. All sovereign, original, indigenous, ancient, divine, Moorish American autographs affirming this and all sovereign, original, indigenous, ancient Empire State of Morocco and the de jure Moorish National Republic federal government documents are on the public record at America, ancient Morocco, northwestern Mexico, the North Gate, West Africa, Turtle Island, Al Morocco, Morocco, Al Maghrib, Al Aqsa, Midgard, Gaia, Midgard, Earth. In the language of my ancient foremothers and forefathers, Amen, Amen, dico vobis, quaecumque algeverite super terram errant ligata et in taiolo, et quaecumque solverite super terram errant soluta et in taiolo. Amen, Amen, dico vobis, quaecumque algeverite super terram errant ligata et in taiolo, et quaecumque solverite super terram errant soluta et in taiolo. Amen, Amen, dico vobis, quaecumque algeverite super terram erunt ligata et in taiolo, et quaecumque solverite super terram erunt soluta et in taiolo. The sovereign justice is complete. Court is adjourned. Malembe, Yezo.